National Lunch Seminar. I think you're in for a real treat. The topic is very timely and relevant. We are the Society for the Psychological Study of Social Issues, and we really could not have put on this event without the help of Congressman McGovern's office, especially Dr. Kim Stanton in his office. So thank you a lot. And we do this series throughout the year. We actually do about 4 of these events throughout the year. So in the fall, we'll be coming up with some new seminars on different areas of research and social issues. So to tell you a little bit about who we are, SPSSI, we were founded in 1936. We are a scholarly association or scientific association of about 3,000 scientists from psychology and related fields, and others who share a common interest in research on the psychological aspects of important social and policy issues. In various ways, as an organization, we really seek to bring theory and practice into focus on human problems of the group, the community, and nations, as well as the increasingly important problems that have no national boundaries. And I'll give you a little bit of an introduction to our 2 speakers today, but you can see their longer bio sketches on the flip side of your handout. Dr. Richard Wiener is the Charles Bessey Professor of Law and Psychology at the University of Nebraska-Lincoln. He is also the Secretary-Treasurer of our organization. Dr. Wiener earned his PhD in psychology from the University of Houston, and he also has a master's degree in legal studies from the University of Nebraska-Lincoln Law School. He applies psychology to problems of legal decision-making and conducts research in the areas of program evaluation, policy analysis, and discrimination. Dr. Wiener also currently consults for the Nebraska Office of Probation Administration, and he has been funded over the years by the National Science Foundation as well as the National Institute of Justice. The Honorable Judge John Colborn, sitting right over there, is our second speaker of the day. He is from the District Court of Nebraska, the 3rd Judicial District, and he also sits on the Justice Reinvestment Initiative Implementation Committee of the Nebraska Supreme Court. He has been in his current role since 2000, and prior to becoming a judge, he served as the Chief Deputy County Attorney for Lancaster County, Nebraska. He received his JD from the University of Nebraska College of Law and his undergraduate degree from UNL. He is a member of the Nebraska State Bar Association, the Nebraska State Bar Foundation, where he is also a fellow, and the Nebraska District Judges Association. And he's served on a number of Nebraska Supreme Court committees over the years, including the Justice Reinvestment Initiative Implementation Committee. And in 2015, he received the Nebraska Supreme Court's Distinguished Judge for Improvement of the Judicial System Award. So without further ado, our first speaker, Dr. Wiener.
Well, thank you for sharing your lunch hour with us. We're going to tell you a little bit about what we think is pretty exciting events that's happened in the last few years in Nebraska. How many of you have been to Nebraska? See, actually more of you have been to Nebraska because if you've driven across country from the East Coast to the West Coast, you've gone I-80 and you've been through Nebraska. You may not stop, but you've actually been there. So we're going to tell you a little bit about what we've been doing with the idea of painting a picture and providing a lesson of the nature of criminal justice reform. And hopefully there's something to take from that you can use. I'm going to introduce the topic a bit and talk about a few basic things, and then Judge Colborn is going to spend some time talking about the legal and policy issues that are associated with the reform movement that's been going on. And then in the end, I'm going to spend some time doing my favorite thing, which is boring you all with some data. Not a lot of data, I promise, just a little bit of data. I have some former graduate students here who hear me say that and they're already frowning and falling asleep before we start. Next slide. So this is a product of University of Nebraska-Lincoln, the Nebraska Office of Probation Administration, and the judicial branch of government in Nebraska. Keep going. Here are the take-home points of our presentation that I hope that you take with you. First of all, the story that we're going to tell is how criminal justice reform took place in a jurisdiction with strong traditional values favoring a tough-on-crime approach. This is not at all an ideological issue. This is really an issue dealing with science and research. A change from tough on crime to smart on crime can increase rehabilitation of offenders, improve public safety, and perhaps partly importantly, it also reduce the cost of the system to operate and save public funds. There's a central role for community corrections in crime reform that we hope to be able to demonstrate in the work that we're doing in our presentation this afternoon. And there's a pivotal role for empirical investigation and program evaluation in any attempts at criminal justice reform. So we're going to try to talk about those issues this afternoon with Nebraska as an example. So this is all about evidence-based decision-making. And you can read the quote up there. The idea behind evidence-based decision-making is to make decisions based upon not just intuition, but based upon sources of information that come together to help improve the quality of the decision-making for policy purposes. Next slide. It involves both the research, the best available research evidence, and I'm going to talk for a couple slides in a minute about what I think that is, along with contextual evidence of what's actually happening on the ground in the area in which you're trying to make policy, and then also experiential evidence of what it's like for people that are doing the work in the area. Our argument is the best policy is made when those three areas come together and form the way, shows the way towards policy reform. So assumptions of evidence-based decision-making. First assumption is that the best policy and program decisions come from high-quality data. And I want to be here the first person to tell you that not all data is high quality. And one needs to be concerned about the quality of data that you're making decisions upon. High-quality data or research is the product of the careful application of the scientific method, where we rule out alternative explanations and we come up with what we think is a good example, at least descriptively, if not causally, hopefully eventually causally, of what's going on in the system that we're trying to understand and trying to evaluate. Data is useful if it's the end product of that sound research design. So just because people say, I've got data, that doesn't mean anything. You know, it depends on the quality of the data and how it was collected and what they're trying to do with that data. And that's an important lesson that at University of Nebraska we try to send off our students with. Next. So incorrectly collected or misinterpreted data is misleading. It is in fact junk science. It should you have to watch out for it. Some data is not always better than no data, but data that's collected well, based on solid research design, that's well interpreted is really the way in which we're advocating, and I think the way in which we did our policy reform in Nebraska. So that's an important lesson. Policymakers, therefore, should use high-quality research to answer questions and make the final decisions that they're trying to make. Okay. So where does this all begin? Criminal justice reform in Nebraska. In 2014, the prisons were 159% capacity. 59% capacity above what they were designed for in Nebraska. During the same period of time, from 2003 to 2014, crime and arrests declined, right? So you might ask yourself, if you're sitting there trying to be reasonable, looking at data that's collected from a policy perspective in sound design, how is it possible that the crime and arrest rates are declining and the prison rates are increasing past capacity? What's happening there, and what seems to be the problem? What do we need to do about that? So in May of 2015, the unicameral in Nebraska has one house, unicameral, passed LB 605, the goal of which was reforming the criminal justice system, at least in part. The goal was to decrease prison overcrowding and lower recidivism, and in the process, there is a heavy emphasis on community corrections and on probation. So the emphasis was trying to see what can we do outside of the institutions in the community to work on this problem of overcrowding and the problem of trying to come up with some standards for rehabilitation that improve the quality of the criminal justice system in Nebraska. So that's what LB 65 was all about. So in a minute, I'm going to step down and turn this over to my friend Judge Colborn, is going to talk about some issues that I'm going to first sort of present for you, get you ready for the judge. First of all, how did Nebraska reform criminal justice with evidence-based decision-making? We're going to look at that. What are the challenges in any state or federal jurisdiction in trying to reform its criminal justice system? I think there's a lesson in what the judge is going to talk about in that as well. What's the role of community corrections in criminal justice reform? And what's the role of the judiciary in criminal justice reform? Next. And in talking about those issues, we're going to have a little bit of discussion of the legal history in Nebraska, the organization of the system, statutory changes, and so forth. We're going to hear about the status of corrections in 2014, the institutional status, the events leading up to reform, and then ultimately the role of the Council of State Governments. Next slide. We're going to look at some policy initiatives, the Nebraska statute, as I mentioned, LB 605, discussion of the major components of that statute, and then perhaps some discussion of rules and regulations, changes in community corrections. So that's what John's going to be talking about. Next slide. I thought that was kind of cute, so I threw that up there. I was going to put a picture of him up there, but I didn't think he'd like that. So instead of that, I'm just going to put up a gavel and sit down and let John talk to us. Oops.
Thank you. During my comments, if you have any questions, please don't hesitate to ask any questions, and I'll do my best to answer them. A little bit about the legal history that led up to our reforms in Nebraska. The way our criminal justice system in Nebraska, and probably similarly in other states, was organized. Individuals get convicted of felonies, and we had sentencing parameters. In Nebraska, we did what is called indeterminate sentencing. So it wasn't a determinate period of years. It was a term of years, not less than so many years, no more than so many years. When a person went to prison, that individual, after they had served approximately one-half of the bottom end of their sentence, they would be parole eligible. That doesn't mean they're going to be paroled, but they were eligible to be paroled. And then after they've served approximately, again, half of their maximum sentence, they were mandatorily discharged, or what they referred to as jammed out of prison. What we were seeing a lot of in a lot of the lower grade felonies, where say someone would be, I would sentence somebody to 1 to 2 years in prison. They would serve 6 months and be parole eligible. In 1 year, they would mandatorily be discharged. Well, what we were seeing was a lot of those individuals didn't want to be on parole. They did not want to be supervised. So they just said, I'll serve the rest of this time and jam out, and then I don't have anybody looking over my shoulder when I get out. And that happened a lot. And depending on how close the minimum and the maximum, say you give somebody 3 to 4 years, they're not going to have to serve too much longer, and they jam out and there's no supervision. And again, there were a lot of people that were doing that. And that was a concern to a lot of us in the criminal justice system, that there was no supervision following their release and their reintegration back into the community without someone providing resources and assistance and supervision to them. So in 2014, we were facing some serious prison overcrowding, and the alternative to the legislature was to build a $500 million prison, and they didn't want to spend $500 million, so they started looking for alternatives, and that's when the Center for State Governments came in to assist us. The legislature formed a committee by statute. That committee was chaired by the governor, the Chief Justice of the Nebraska Supreme Court, and the Speaker of the legislature, and a number of us were appointed to serve on that committee. And that committee was looking for alternatives to building new prisons and to reduce recidivism, as Professor Wiener said. We did quite a number of studies. Are you familiar with Pew Trust? People, they have put on a number of conferences and have led the way in justice reinvestment. A number of us from Nebraska attended a conference that they put on. I think there were 37 states there in attendance at that, talking about justice reinvestment and suggested ideas of how to do that. Once all that was completed, the legislature first introduced LB 605, and that was enacted, and it did a number of things. One of the things it did to reduce prison population was increase the values of crimes. Say property crimes, what was a felony was $500. You steal $500, that's a felony. It then became $1,500. So that took a lot of people out of hopefully the prison system based on just the inflated dollars from when those laws were originally passed to 2014. It also changed the penalties and the way we did sentencing, especially on the lower grade felonies. We still have indeterminate sentencing for what we call Class 2A and higher penalties. Class 2A felony is 0 to 20 years. But all the crimes below that, the Class 4s, 3As, and 3s, are determinate sentences. But in addition to that determinate sentence, the judge has to, not optional, has to impose post-release supervision. And that was to avoid people from jamming out of prison. So they may want to jam out, but they're not going to. They're going to be supervised when they're released from either jail or prison, depending on whether they get a jail sentence or a prison sentence. So even if I put somebody in jail on a felony for 6 months, they're still going to have 9 months of post-release supervision, a minimum of 9 months. And it can be as much as 2 years of post-release supervision on the Class 3 felonies. So again, the idea was to provide services to these individuals, treatment that they need. But the important part of that, the legislature wanted to save $500 million and not build a new prison. But in the alternative, you have to spend some money. Not nearly as much, but you have to spend money. You have to put that money out there for the resources that we need. The treatment dollars, the supervision dollars. Our probation officers, I don't know, I can't remember how many we added. I don't know if it was 80 or 100 new probation officers in Nebraska to deal with all the people that were going to be on post-release supervision. There's still people that will be on parole on the indeterminate sentences. The parole administration, and I don't mean to say anything negative about the parole administration, they were not using evidence-based practices, and Professor Wiener will talk about a little bit more here. Our probation had been using evidence-based practices to assist the judges when they prepare a pre-sentence investigation, PSI, that I read to help me determine what the appropriate sentence is going to be. We had already been using the probation, or excuse me, evidence-based practices, but parole was not. So one of the things in LB 605 now requires the parole administration to use evidence-based practices in determining how to supervise individuals that are going to be on parole. After 605 was enacted, we found there were some oversights in the law, and LB 1094 was kind of a cleanup bill. And one of the things we wanted to avoid was having people on probation and parole at the same time. So if somebody got convicted of an older felony or a higher grade felony, they would be parole eligible. But if they got convicted of one of our new LB 605 Class 3, 3A, 4 felonies that I'm supposed to do a determinate sentence and post-release supervision, those didn't combine very well together, and we didn't want to have somebody being supervised by a parole officer and a probation officer at the same time. So we took care of those problems, and for the most part in any event. And people will either be on parole or on post-release supervision, but not both at the same time. One of the other things that was done, when I would put somebody on probation, if that person violated a term or condition of their probation, didn't matter what it was. They could either do a law violation, commit a new crime. They could not show up for their testing. That's a violation of their probation conditions. They could not show up for their appointments. A variety of things. They could use drugs again or use alcohol. And they could be revoked for all of those things. LB 605 said we can no longer revoke somebody's probation unless and until, unless they commit a crime. If they commit a crime, you can revoke them, a new crime. But if it's a substance abuse violation or a non-criminal violation, they have to serve 90 days of jail sanctions before we can revoke them. And that was, again, to avoid a whole lot of people getting revoked and getting sentenced to prison that had been on probation. Again, hopefully to ease the overcrowding in the prisons. So an individual, the maximum jail sanction is 30 days. So they have to have at least 3 of those before we can revoke their probation unless they commit another crime. And I think that's helped reduce the number of people that are being sentenced to prison for not doing everything they're supposed to be doing on probation. And it gives probation an opportunity to continue to try to work with the individual and throw the resources that we have towards them to keep them on the right track. There are graduated sanctions, first with administrative sanctions, depending on the nature of the violation. They have a matrix they use and follow to determine what the sanctions should be, or a range of sanctions. And I think that's been helpful. We recognize, you're probably familiar with problem-solving courts, drug courts. We just started our Veterans Treatment Court yesterday in Lincoln. We had our inaugural ceremony, and we know that people, when we put them in treatment, they're gonna stumble. They're gonna have problems, and so that's kind of the theory also behind probation now. We know people are gonna stumble. They're gonna go back and use, but we need to keep working with them as long as we can to give it the best effort to use the resources we have to get them back on the right track. With that, the judicial training and our response, because I was involved with the Justice Reinvestment initiative, I get to do all the training for our district judges that handle the felony cases in Nebraska. And we've had a positive response, and I think things are going really well with the implementation of LB 605 and the refinements in LB 1094. So with that, Rich, any other? Yes, sir.
Let me ask you, I'd like to ask a couple questions. And I know that
I meant anybody except him could ask questions. Go ahead.
and I want to preface this by just saying that I know there's things that you can't talk about and questions that you can't answer. So feel free to tell me, no, Rich, I'm not going to answer that question. But I'd like to know, in the process of doing this reform and passing this legislation, what was the process like? Were there challenges from various sectors, and was it an easy go, or did it require a lot of education and a lot of work to get it passed?
It was not an easy go in the sense, LB 605 was over 100 pages long, and the training that I did for our judges, it was like 3 hours of training the first time, and then we did several what we call webinars where I would do an hour long over the lunch hour with updates on the issues that we were seeing and how we were dealing with them. Because a lot of the questions in LB 605 had not been answered. The legislation wasn't as clear as it could have been. And I know you all see that sometimes where you have to clean things up, or the courts are asked to interpret what something means in the law. And we were struggling with that, and judges, we would have conferences and seminars where, okay, we just throw it out there. What does everybody think this means? Or how is everybody going to handle this? With our, one of the things in our cleanup bill was, how do we handle custodial sanction hearings? They have a right to a hearing. Well, what are the rules? What type of due process are they entitled to? What's the standard of proof? Can the judge increase, say the probation officer says, I want 7 days of jail sanctions. And it comes in, the judge goes, no, I think that ought to be 30 days of jail sanctions. Can the judge do that? I didn't think you could, but there were some that didn't necessarily agree with that. We cleaned a lot of that up in LB 1094. So it took a while. And again, it was complicated. It was a whole new way of doing things for us. And a lot of little rules, depending on the nature of the felony. And again, anytime you change stuff, so did the new rules apply to the old cases? And depending on what stage of that case was in, what were we going to do? Were we going to apply the new rules to that or not? So as always, it's not simple to change. People are resistant. But our judges really did a good job. And the case law that we've had since then shows that the way they're interpreting the law and in enacting or in implementing the law has been relatively smooth. So.
Is there any questions?
How about public acceptance? Have a lot of pushback.
I don't know that I have seen any pushback. That was a concern, and when we were out in California for the Pew Trust conference, that was one of the things that they brought in speakers from all over the country, including some people from Washington, about what kind of pushback are you going to get here, and is it okay? I mean, are you going to be labeled soft on crime? And for senators in our unicameral, are they going to vote for this? Are their constituents going to say, hey, you're being soft on crime? You're putting, you're letting more people out of prison. These people need to go to jail. Or do they need treatment and help in rehabilitating them and putting your money in those kinds of resources? And frankly, nationwide, I think there's been general acceptance. As I said, when I was at the conference, there were 37 states there. So I think there's been a movement towards that. I'm not saying there hasn't been some pushback and I've seen some complaints recently in the media about other states where people are questioning some of those things. But
so related to that, was the process that this commission sort of constructed a plan and then presented it to the legislature publicly, or was there a lot of public discussion?
Well, all of our hearings were public hearings, so each of those hearings was chaired by the governor and the speaker and the chief justice. The public was welcome and was welcome to make comments. CSG kind of ran the meetings. The individuals from the Center for State Governments, they came in, and much like with what Professor Wiener had a lot of data to show us about what was happening in our prisons, what was happening, how many people were jamming out of prison. They weren't getting supervised on parole. How many people were being put on probation for Class 4 felonies. And one of the other things in LB 605, the legislature made a requirement that if I was going to not put somebody on probation for a Class 4 felony, I had to make a finding of substantial and compelling reasons why I was not putting that person on probation. And again, encouraging you to put people on probation for the lower grade felonies. And prior to that, the law required us to consider probation first. So this just added the words substantial and compelling reasons. Personally, I felt I was already making those kinds of decisions. If I didn't put somebody on probation before LB 605, it was because I had a substantial and compelling reason not to. We think about probation first, and I think statewide that's true. But the Center for State Governments gave us all that information. We looked at it, and then they came up with some recommendations. Those were submitted to the committee, and then there were 3 or 4 state senators on that committee. They came up with LB 605, the introduced copy. And there was some pushback from some prosecutors in the AG's office on certain types of crimes. They were reducing some of the penalties for certain types of crimes, and through some negotiation, some of those remained higher grade felonies. But ultimately, the bill passed. I don't know that it was unanimous, but it was passed easily.
And I'm not sure that I would say that all the judges in the state were considering compelling reasons for not.
That could be.
Some of the other judges may not have been doing.
That could be. But it certainly, in LB 605, they said, you must make those findings. And so whenever I do not put somebody on probation on a Class 4 felony, I make certain findings. I specifically state on the record that I find substantial and compelling reasons not to put the person on probation, and I list all of my reasons, and they're all set out in the statute, and I decide which of those statutory reasons apply for me to reach the conclusion that I did. But again, we look at probation first, and alternatives to incarceration is, I think, what community corrections is all about, and what this is all intended to do. And we don't want to build new prisons.
So we'll get a chance to ask some more questions later. I want to could let John talk forever, but I like to talk too. All right, next slide. That's me, law and psychology, University of Nebraska, Lincoln. Next slide. So this is heavily based on the role of community corrections, as you've heard, and probation in our Reform Act. Offenders with lower felony convictions sentenced to probation are sentenced for services and supervision instead of prison. That's sort of the motto here. And after release, post-release supervision under Nebraska probation, again, for the purposes of engaging in services, receiving services, and treatment and supervision. And so the effort is to increase to rehabilitate and support reentry through modified sentencing that you just heard about and evidence-based practices. So I'm going to talk a little bit about what we mean by evidence-based practices and assessment and so on. Next slide. This is all based on a standard model in criminal justice called the risk-need responsitivity model, R&R, developed for a long time. Probably its high point is Andrews and Benita in 2010. The issue here is to assess risk by looking at criminogenic needs. And I'll talk about those more in detail in a second. And then intervene through techniques that are evidence-based, that there's actual evidence to show they work, and that are tailored to the characteristics of the particular offender, because some offenders do better under certain kinds of treatments, and other offenders do better under other kinds of treatments. Next slide. R&R. 3 components, really. Assessing risk, and the idea there is, you want to invest your resources in the people that need them the most. You want to identify people that you're probably not going to be successful with, and you want to identify people that you probably don't need to put a lot of resources into, right? So you want to be able to figure out where that risk is most focused. Evidence-based practice. We want to only use practices that we know work. And in states like Nebraska and probably 50 others, there's a real tendency to use treatments that are quick and efficient but don't necessarily work. And then once again, tailoring this to the individual needs of people. Next slide. So I'll first talk about assessing risk a bit. In Nebraska, we use the level of service case management, or the LSCMI. There are a number of maybe 15 or so instruments out there. 5 or 6 of them are really good that people use in various states and in the federal system that have good validity and reliability to the instruments. Next slide. The level of the LSCMI measures these areas of criminogenic needs, those 8 areas. Criminal history, education, employment, you can read them, I don't have to read them to you. And it measures each of those areas through an elaborative interview that the probation officer engages in. Every individual is rated from very low to very high on those 8 criminogenic needs, and we get a total score. And that total score becomes a risk score for that individual. Next slide. The same criminogenic needs also document the needs of the offenders to form individualized treatment plans. So if the guy or the gal is really high on alcohol and drugs, you aim at that. If they're really high at antisocial pattern, you aim at that, and so forth. And so the probation officer comes back with a risk score. How risky is this individual, and what kind of services are required? How much concern do we have for them? And then also, what are their needs? What are the kinds of things that we need to target when we offer services to those individuals? Next slide. And so the empirical question here for criminal justice reform, anywhere you do it, in any jurisdiction, federal or state, there's 2 empirical questions. Is the risk assessment a valid indicator of risk? In our sense, in our case, is the LSCMI a valid indicator of risk? And in our case, is the LSCMI a valid and reliable predictor for Nebraska probationers? Because just because the instrument is working in Idaho or New York or California, you get suggestive that it might be working pretty well in some other place that you transport it to, but that's not enough, right? You have to actually document that it's working in the place that you've switched it to, and there might be need for changes in the norms and changes in the way in which the instrument is being used. So those 2 empirical questions that are important for any system that's operating to try to bring this about. Next slide. So I'm going to digress here a bit and tell you a little bit about what a meta-analysis is. Very little. Meta-analysis is a quantitative review of a large number of studies. So there's been hundreds of studies that looked at the validity of the LSCMI. And what we do with the meta-analysis is it gives us statistical estimates known as effect sizes, how big the effect is, how strong the prediction is, that are usually talked about by R values. And they test the relationship between a set of predictors in this case, that would be the scales of the LSCMI, family of instruments, and outcomes. Outcomes are almost always recidivism, defined lots of different ways, but almost always does a person return in some capacity, right? Next slide. And so the results of meta-analysis measure the strength of the relationship between the predictors, here the LSCMI, criminogenic need scales, and an outcome measure, recidivism. So Oliver et al. Did, in 2014, a meta-analysis of 128 studies of these scales worldwide. It's used a lot. It's used in lots of places. And here's results. The effect size in Canada, R is 0.43, probably high in Canada because first it's developed in Canada, and secondly, it's really easy to do this kind of research in Canada because they don't have so many different jurisdictions. Outside North America, the R value is 0.29. In the United States, using the LSCMI, the R value is 0.22. So at this point, you should be saying to yourself, well, what the hell does the R value mean anyhow, right? And so I have the next slide, I hope. Yes, I do. Common effect sizes, okay? So the relationship between Vietnam veteran status and alcohol problems over the years has an effect size of 0.44. And you can see some of the other effect sizes. The relationship between beta-carotene as a cancer prevention drug and cancer prevention has an R value of 0.20. Anything below 0.20 is negligible effect. It's not clear if it's very useful at all. If you can't predict at least at that value of 0.20, it's not so sure it's a meaningful relationship, right? And in the meta-analysis, can you back up one? In the meta-analysis, notice in the United States overall, the effect size is 0.22, not so good as Canada, but still pretty meaningful. Okay, now drop down 2 more. This is Nebraska, right? We did this major study. We looked at 19,344 Nebraska probationers from the years of 2007 through 2013, 5.5-year window, and our R value is 0.21. First thing to notice about that slide. Second thing to notice, we have risk level on the bottom. We have probability of failure along the other side. That as the risk levels increase from very low to very high, what happens? The probability of failure increases dramatically, right? That's what a reliable and valid indicator of risk ought to be able to tell you to do. Now, what we need to do is we need to, that's okay. But if you look at the medium high area and medium low area, that's where we need to be putting the resources in, because that's where we're getting pretty high recidivism. And recidivism here is defined as returning to probation. I'll show you a better recidivism slide if I get there in a few minutes. But this is the form of the relationship you want, and an R value that's at least as good as 0.21. So what do we take away from that? We have a risk indicator, a risk assessment tool that is in fact reliable and valid, that is able at some level, a lot better than intuition, judge, and chance, that can actually classify people into categories of risk. And so that really helps the system operate. Next slide. So now I want to talk about evidence-based practice and what we mean by that. Remember, the first goal of the R&R model is you got to do good, valid assessment, and the second goal is we want to have evidence-based practices. Next slide. Evidence, that's Q2. Next slide after that. Evidence-based practice means that the simple, very simple. Lots of discussion of evidence-based practice. People hear it, use it a lot. It gets dropped around as an important comment a lot. The basic idea here is that an evidence-based practice are interventions that researchers have shown empirically, have tested empirically and shown to have measurable positive outcomes. That's all there is to it. There has to have been some research somewhere, sometime, that's been done on that technique that shows that it's effective. That means that there is some experimental or quasi-experimental, I won't get into that, but there's some experimental evidence that shows that a treatment group outperforms a control group on the expected outcome. If there's not been a study that demonstrates that for that particular intervention, it's not evidence-based, period. End of story, okay? Now, there's techniques that are promising, that are working their way along, that could be evidence-based eventually, but the idea, the bottom line behind an evidence-based practice is, in fact, you've shown experimentally that it works. Next slide. Having said that, there's 3 ways in which people try to measure evidence-based practices in practice. One is you do an experimental or quasi-experimental analysis of an existing program in practice. You collect the data, you get a treatment group, you get a comparison group, and you make the comparisons. The second way is that there's the models program approach. So there's websites and there's literature. SAMHSA is one of them. The American Psychological Association has another one where there's lists and evaluations of interventions that have been tried and how well they've done. What does the literature say about them? How successful have they been? What does the research say about the success of that program? And that's sort of the model programs approach. Okay? The third approach, because I talked about meta-analysis, is a really interesting, new, and important way to think about evidence-based practice. So if I have a meta-analysis that's looked at 500 studies of interventions with juveniles, and I find the following 7 characteristics are important: training of the facilitators, risk level of the participants, whether it's cognitive behavioral intervention, and so on. I find that those 5 or 6 or 7 or whatever it is attributes are important for that kind of program. Then I can begin to look at the existing programs and see if those attributes match on to the program that I'm looking at. So those 3 techniques are used all the time to in the literature and all the time in practice to try to say this is or is not an evidence-based practice. Next slide. So let me give you an example. Relapse prevention in Nebraska is an example I'm choosing to use. There's lots of others. The case that many offenders in community corrections have substance abuse problems that lead them to reoffend and enter into a criminal justice revolving door, as Judge alluded to. Release, reoffend, release, reoffend, release, reoffend for a long time. And so the question is, what can be done to improve or interrupt that system to try to undo that relapse that continues to occur? And so we have this relapse prevention program. Next slide. In Nebraska, we use what's called interactive journaling. That's the program that's been adopted and used in Nebraska for relapse prevention. It's a cognitive behavioral intervention process, a self-reflection that guides this individual, probationer or inmate, what have you, excuse me, through a process of change. And you can read the steps. It goes through the process of change. The clients engage in expressive writing to examine their own issues related to change and criminal thinking. So it's been a well-known, tested cognitive behavioral technique. Next. Interactive journalism is on SAMHSA's National Registry of Evidence-Based Programs and Practices. That's where Nebraska got it from. It's a model program that Proctor, Hoffman, and Allison tested in 2012 and showed that it was in fact effective. And showed that people that were doing it, when they came out, they had a lower recidivism rate than people that weren't doing it. Okay? And there's a number of other studies that support that. But that's not enough. Next slide. Not enough because it doesn't mean just because it worked in the program that it was tested in a laboratory or somewhere in some state, it's going to work in the state that we're interested in this case, Nebraska. Nebraska Probation continually monitors relapse prevention with a series of pre-tests and post-tests that were developed by watching the program in progress, measuring the program, looking at the materials, looking at the curriculum, and figuring out exactly what kinds of changes should have been ongoing from pre-test to post-test while individuals go through that procedure. So we have a model program that's had research that supports it, right? It's been tested empirically in an experimental process. Plus, we have, next slide, all of these factors, understanding relapse process, understanding warning signs, positive self-talk, cost of engaging in drugs, and so on, that show a positive change from the beginning of time when the person went into the program until when they left. We also have comparison group data that shows that change doesn't occur when people aren't in the program. And so we're constantly monitoring this evidence-based intervention to make sure it's doing what it's supposed to be doing. We check the fidelity that people are carrying out in the right manner. And so we know that for this particular technique, that we're getting the bang out of the buck that it's supposed to produce for evidence-based practice. Next slide. And so next question I want to ask, and yeah, there we go. Wait, I think that's right. Back up one. Go on down one. Yeah, I think I got these in reverse order. Go down one more. Stop there. Nope, back up. It was right. Excuse me. Whoops. Okay. Put this together early this morning. All right. Has a reliance on community corrections and the R&R model worked for Nebraska? So the bottom line is, so what, right? Lots of talk, lots of change in legislation that could or could not be a model. Lots of talk about not wanting to build new prisons, and all this talk about risk and assessment, and all this talk about evidence-based practice. So what difference does it make? So we're very interested in answering that question. We work hard at answering that question. We try to measure it and try to be able to understand where we are in the process. This is a recent data released from the U.S. Department of Corrections, 2016, in a study called Recidivism Among Federal Offenders, a Comprehensive Overview. Take a look at some of their numbers. Of 25,400 former prisoners released outright or on probation, 31% had been reconvicted within I think it's a 2-year window. Rearrest rates for federal probationers who were on probation was 35%. Reconviction rates for those paroled was 31.7%. So it's pretty high, pretty substantial people that are turning around and coming back in. And so we wanted to know, next slide, what happens in Nebraska? Nebraska's been using this assessment technique for a while. We sharpened it with the passage in Evan of LB 605. We collect data constantly. We're reviewing and examining these programs. We have an assessment procedure that we've tested. We think it's reliable and valid. What difference does it make? Does it work? Does it have any kind of successful impact? So we used a database recently containing 65,058 cases of Nebraska probationers released between 2006 and 2012 to calculate recidivism as the Nebraska Supreme Court defines a term. So we went to the Nebraska Supreme Court rules and we said, okay, guys, what you say probably matters. You know, you are the Supreme Court of Nebraska. I think what they say actually does matter quite a bit. And we said, what's the rule that you use for defining what recidivism is in the state? Next slide. So that's the rule. Nebraska Supreme Court definition. As applied to adults, recidivism shall mean a final conviction of a Class 1 or Class 2 misdemeanor. You can read the rest. Enacted in conformance with state law within 3 years of being successfully released. So it's a high misdemeanor or felony conviction is what counts in Nebraska when the court thinks about what constitutes recidivism within a 3-year window. Next slide. So we took these 65,000 people that were in the probation system. We collected data from another database, Justice, looking at outcomes of convictions, at least in Nebraska, for that sample of 65,000 people. The sample looks like this. They're mostly white European, some African Americans, pretty good sample size of Hispanics. They were mostly men, but there were some women in the sample. And what did we find? This is what we found. The overall recidivism rate for successfully discharged probationers from probation in Nebraska is 14.2%. Okay, so I don't know how many of you are involved in criminal justice work or research, or that's a really good number. That's a really good number. Okay, so something's going on that's very successful. You can see
it's prior to the reforms, right?
That's both prior and during the reforms. So it's over. No, you're right. It is prior to the reforms. Yeah. Okay. But you can see the number is 14.2%. Next slide. Recidivism rates for successfully discharged probationers over this 6-year window stays stable at about 14%. A little bit of variation of a point or above. Yes.
Was the sample that you used representative of the current prison population? So if it was like 10%.
Back up for that. Could you take a look at the sample? It's representative of the current probation population for sure.
Okay.
I can't really speak to the prison population. If I had to answer that question, I'd say no, right? Because I suspect you got in the prison population more African Americans and more Latinos than this would represent.
So that is representative, like it's an exact ratio?
It is, in fact, representative of the probation population. Okay? Yep, next. But we have been using evidence-based practices and assessment all along during that time period. Anyways, so this is the recidivism rates for successfully discharged probationers from 2006 to 2012. It hovers around 14% with total variation of less than 1%. There are no significant changes over time. It has been stable at that level of 14%, and that's really any fluctuation that just represents error. I'll also point out, I had another slide, but I didn't put it in. Over that period of time, the risk level has been increasing. Risk level has been increasing over that period of time, and the level of recidivism stayed flat. Next slide. Not to make the picture too rosy, when we look at, now go back again, go back one more slide. These are all 65,000 people in the system, some of whom are pretty low-level offenders. Could be DUI ones, you know. So that's everybody in the system. Next slide. These are the people who are more serious misdemeanors and or felons. They are people that have in fact been scored with the LSCMI, our risk assessment device. It's only given to people who are high-level misdemeanors or felony probationers. And this is interesting for two purposes. First of all, it shows you overall on these 10,000 people that are the higher risk felony individuals, the recidivism rate is still only 20% overall. That's point one. Point two is, notice that from very low risk to very high risk, there is an increase step by step in the recidivism rate, right? So this is more validation that this instrument, the LSCMI that we're using for predicting risk, is in fact a valid instrument that predicts risk and behaves in the way you would expect it to. But still, when we look at the very high risk assessed people that we're looking at, those 428, their risk level gets up to be about 32%. But overall, it's down at 20%. And in fact, if I was going to make the case, I would say the people we should be focusing on are the people in that medium and high group, that 4,243 and the 2,434, whose average risk is somewhere, around 25%. Those are the people that we can probably do something with through evidence-based practices and rehabilitation techniques to try to move down the recidivism rate, make the public safer, and spend a lot less money. Okay, next slide. So what are my conclusions from this? And then we'll have time for lots of questions from either one of us, and we'll be happy to see what we can do. Justice reinvestment approaches rely on an evidence-based decision-making strategy. In Nebraska, I'm proud to say I firmly believe that the way this all came about, kicking and screaming sometimes, with lots of debate, people in Nebraska looked at the data and said, we have a problem here based upon this data, and looked at the literature and said, here's some techniques to try to solve this problem, and acted in that capacity. My second point that I would say is this: being smart on crime may produce better results at the state and federal levels than simply being tough on crime. There are only so many resources available for the criminal justice system and for these types of interventions. Using them wisely, being smart on crime, by using valid assessment tools and by using evidence-based practices, makes that dollar that you're spending go a lot farther than just a knee-jerk being tough on crime reaction. That's my second point. The third point is the R&R model with an emphasis on valid risk assessment, evidence-based practices, and individualized treatment plans can reduce recidivism. And then fourthly, successful crime reform requires ongoing empirical measurement and evaluation to make sure that what you're doing makes sense, that it's working, and to make adjustments along the way. Next. I think that's all we have to say. So we'll be happy to answer any questions that you have about the law, the process, or the data. Yes?
I just wanted to know, do these reforms just apply to the adult side, or did it also apply to the juvenile justice side? And did any of these practices, have they been applied to the juvenile justice side, and has there been any success with that?
Well, I deal with adult court, and but I assume they're using the evidence-based practices in our juvenile probation, which is all under the same umbrella of probation. So pretty confident that they're using the evidence-based practices. LB 605 is dealing with adult prison populations and the overcrowding of prisons. So I don't, and our Justice Reinvestment initiative really didn't address the juvenile issues. That we have had separate committees that have dealt with juvenile justice issues, and we're certainly involved heavily in that. I personally am not just a court judge.
I do work with both the adult side and the juvenile side. The juvenile side has a database to calculate recidivism that has just been handed to me a couple days ago, so I can't tell you what the actual numbers are at the moment. There's a major effort towards using evidence-based practices and a valid assessment tool that we have just validated, which is we use the YLS, which is like the child's version of the LCMI. So we did a major study validating it to show that it in fact is doing what it's supposed to be doing and predicting. But I think the legislative actions on the adult side have not really been, reform has not really occurred on the juvenile side in the same way. But I would say there's a major effort at trying to replicate those kinds of conditions in the juvenile justice area.
Just a little follow-up on one of the prior slides here, where you have a high-risk, high-needs individual that had, what, a 32% recidivism rate.
Right.
That doesn't mean as a judge I'm not going to put that person on probation, however. I put people on probation that have been to prison before a couple of times. If I think this time they're very serious about dealing with their substance abuse issues. And oftentimes, if while they're awaiting sentencing, I'll continue the sentencing for them to get in a treatment program, including I'll let them out of jail to go to an inpatient treatment program. But I continue the sentencing because I want to make sure they're serious. They really, truly want to get the help that we're offering to them. And then even though they've been to prison, I will put that person on probation. I know it's a high-risk, high-need person, and going back to what I said earlier, you need the resources. You got to have the dollars to provide those resources to those individuals that you can be successful with them, for sure.
Yeah.
And I agree with Professor Wiener about the middle people there, those are the ones that we can certainly have a lot of impact on. But once again, I want to make sure that they're serious about wanting the resources that we have to offer to them. And sometimes you have to force them on them. Don't get me wrong, and we do push them on them, and successfully.
But the alternative is letting them jam out, and then
then
they have
there's-
no supervision and no services, and then you're guaranteed they're coming back in.
Absolutely, and that was the whole theory behind our drug court. Earlier, I was in the prosecutor's office for 21 years before I became a judge. And right at the end of that time, right before I became a judge, we implemented a drug court. And I was the chair of our implementation committee, planning committee and implementation committee for our drug court. And the whole concept was that, if you have a drug addict and you put them in prison, what do you think they're going to be when they get out? A drug addict. You have not dealt with their issues. And prisons, again, I don't want to make denigrating comments about, but they didn't have the resources and they didn't provide the needs of those individuals. And they came out as drug addicts. And then that cycle that you talked about earlier, you know, they get convicted, they go to jail, they get out, they repeat their crimes, and they go back to jail. And so the whole concept there was, what can we do to stop that? And providing those resources and the treatment and the level of supervision, high risk, high needs, lots of supervision. Low risk, low needs, our probation people pretty much leave them alone, and they should, because some of those folks, you get them into the system, the more and more you get them into the system, you make them worse, because they're now hanging out with people that you don't want them to associate with. So, yeah.
Hey, thank you for that talk. I was interested if you could elaborate a little bit further on what you do to integrate back into communities. You mentioned journaling, you mentioned services if they have drugs, substance abuse issues. Do you do anything with education, helping them find jobs or other integration?
Absolutely, that's all part of our probation. You know, they have cognitive therapy classes, mental recognition training, vocational services. They try to help them find jobs. They try to get them into vocational
Yeah, there's a huge
programs.
effort of reentry that we've launched on in the last few years, and it's a work in progress. But a lot of progress has been made. A lot of work at trying to find work for people. The best predictor of failure in reentry is if you don't have a reasonable. And I mean a job. I don't mean washing dishes 20 hours a week. I mean a regular job that you can make a livable salary and have a life on. And there's been a lot of effort working towards developing those kinds of programs to help people who are in reentry come back and find those kinds of positions. Difficult task. Another area of research that I do looks at how employers make decisions whether or not to hire somebody with a record. And it's a hard nut to crack. But if you're going to improve the quality of rehabilitation and get people, you know, back into respectable lives and reduce the fear of public danger, you have to work on those. So we do that. There's a big major job interventions, all kinds of other things.
And as to follow on with that, and maybe this is something you already know, but if you talk to pretty much any probation officer or parole officer, they'll tell you the single most important factor of whether that person's going to be successful on probation or parole is, do they have a job? If they're working, you know, they have something to live for each day, to be proud of, they're working, and they're not hanging out, at least during those hours, with people who they associated with before that were committing crimes. And it's, I mean, you talk to a parole officer or a probation officer, that's the single most important factor. And that doesn't take away anything from treatment and counseling. Those are also hugely important. But that single factor, you'll find that if they're not employed, they have a higher risk of reoffending, for sure.
So I have two questions. One, just to go back to what you were talking about earlier, was the collection of data leading up to the law change something that helped with the law change? Meaning,
I would say definitely yes.
so years of documenting.
There's no question.
Okay.
So you know, both by the university and by council of state governments, there's been lots of efforts at here's documentation and here's what's going on in the system.
Okay. And the second question is, there's a bit of a debate in the world trying to figure out this reinvestment stuff around where does the formal system end? You know, when does probation officer, when does the justice system end, and when does community begin? sort of the community part of community corrections. Maybe you could just talk for a minute about in terms of the money that was reallocated that was supposed to be spent on the prisons. How much of that was sort of moved in, either re-granted from probation or from the judiciary to community-based organizations, and what does that kind of look like?
I can't, can you? I don't know exactly what the dollar figures would look like in
Or
terms
even,
of.
even experientially.
Yeah. I mean, there were a lot of dollars appropriated, and the court system made it very clear that if we were going to do this, you had to allocate the money.
I think a lot of the money's been allocated through probation, and what probation really does is it hires service providers. And the service providers are people that do the work out in the community. One more thing about Nebraska, we have a set of reporting centers throughout the state. And so probationers and/or sometimes parolees come back to the reporting centers for many of the services, but also the services are offered in the community. People get vouchers to go to partake in those services. So there is I can't tell you figures, but there's a good deal of money that's been allocated to those services. Not enough, I would still argue, not enough. But the fact is, there is money that's allocated to those services that are offered in the community.
The money was appropriated and is being used by probation to provide vouchers for treatment and the day reporting centers.
Another big component is that Nebraska just finished standards. I helped write standards for reentry courts, which are like drug courts or other problem-solving courts, but focused on the population of individuals that are in reentry. And so I don't know how familiar you are with problem-solving courts. The idea is the judge acts more, or at least as much as like a caseworker as a judge, and they monitor people as they go through services and treatment and provide supervision. And the idea is to be both motivating and to be encouraging, and to make sure that the services and the treatments are in place. So we've had a system of drug courts for a long time, but now we also have reentry courts and veterans courts.
Yeah. And the concept behind, we have an adversarial criminal justice system. You've got a prosecutor on one side and a defense lawyer on the other, and it's an adversarial setting. The judge sits as the impartial magistrate. In our drug courts and other problem-solving courts, we work as a team. The adversarial stuff is out the window. We all work together towards helping that person deal with the issues while they're in that court. And for drug court, we're trying to deal with their drug addiction and help them get past that and become a functioning member of society, law-abiding, functioning member of society. And we work together, so it's not us against them from the prosecution and the defense standpoint, and the judge actively is encouraging the person. So prior to problem-solving courts, I see somebody, they come in, they either plead guilty or they have a trial, then I sentence them, and I never see them again. But in problem-solving courts, I see them every week or every 2 weeks, and then they get further into the program, we have them come in once a month. But I'm engaging with that person, asking them about, tell me about your children. How are your kids doing today? How's your kid doing that in their tournament this weekend? We get to know those people, and everyone is working to help them. And I've been to a lot of graduations around the country, including in our jurisdiction, where these people, and it's not just the judge, but they're going, Judge, you changed my life. You turned my life around. And it's the first time anybody has shown that they really care about it and want to help them. Instead of, they come into my court and I just go, okay, 6 months in jail or probation, and then I never saw them again. And I never got to know them. I never got to encourage them to do the right thing and to seek the treatment or take advantage of the treatment and the vocational services and all the things that we're trying to do to help them. So it's a different setting completely. It's not adversarial. That doesn't mean it doesn't get adversarial. If they mess up, there are sanctions, like we talked about for people on probation, graduated sanctions. And occasionally then the defense lawyer has to put his or her hat on and say, well, maybe that sanction should only be 3 days and not 7 days. Or you really shouldn't kick this person out of drug court, because they give lots of chances. But ultimately, it's just not working, then they terminate them from that problem-solving court, and they go back to be resentenced, or to be sentenced, because they were never sentenced in the first place.
So you discussed how having meaningful employment
Well, I think that's something where the probation officers have gone out in the community, and I know our drug court people, our drug court coordinator, they go out in the community and they find employers. Take a chance on these people. And you'd be surprised how many employers are willing to do that and will. But again, I think it's one of the suggestions that I had when we were doing this Justice Reinvestment initiative was, instead of building a prison, why don't you, with $500 million, why don't you build a facility? And we just had a university, Dana College, up north of Omaha, had just gone under. I mean, it terminated. So you had this campus. I said, build a fence around the campus. You got all the classrooms where we can do treatment, we can do vocational training, we have dormitories, they can sleep there, and these are all minimum security people. Because of our 5,000 people in prison, about 1,500 of them are minimum security people. They aren't the people we lay awake at night worrying about being out on the street and hurting us. These are minimum security people. Get the vocational training there at the facility, get the treatment, and then reintegrate them back into the community, get them jobs, internships, whatever it is. And it was my opinion that would be very successful. That didn't get a lot of traction. Instead, we ended up with.
Well, I was going to say, how did that go down? How did that work?
Well, it didn't. But we had a new corrections director, and I asked. He came from Oregon, I think.
Washington.
Washington. And I asked him, do you have minimum security facilities? Did you have them in Washington? He said, yeah, we have wooden structures. He called them wooden structures instead of the brick and mortar stuff. And I said, do those work? He said, yeah, we have them all over. And I said, is that something you envision for Nebraska? Because give me time. And he's only been here, what,
couple years?
Yeah, a couple years. So we'll see. But I thought the minimum security facilities where if they walk away, we'll find them. And they aren't the people we worry about. But what a perfect place that campus would have been, because you could bring in people, all kinds of vocational people to train, to teach them trades, all different kinds of things that they could take with them and go out and not just a minimum wage job, but an actual job, a trade, something they could be proud of and work at, and get the alcohol and drug treatment they need, and mental health. And that's another thing we're looking at is mental health courts, which is a huge issue. And we get so many people that are dual diagnosis. So they got mental health and substance abuse issues. And they're difficult to deal with in our drug courts. It's hard to deal with because you've got to have both components there if you're going to effectively deal with their issues. So.
Two real quick questions. Reaction of prosecutors to this, and has the overcrowding of
The overcrowding of the prisons is a little bit better. It really is starting to see a bit of a change. It will take time. It's not gonna disappear overnight. But in fact, the prison overcrowding is a bit better.
And one of the things on that prison overcrowding, it's kind of hard to know because in Lancaster County, which is the 3rd Judicial District, Lincoln, Nebraska, where the university is. Lancaster County in 2015, they filed 1,400 felony cases. In 2016, they filed 2,000 felony cases. So we had an increase of 600 cases in 1 year. And so I don't know how that affects the prison. It's hard for the prison population to go down when there are 600 more felonies that are coming into our courts in 1 year's time. And we don't know if that's going to go back down this year, but right so far it hasn't. But a lot of those are drug cases that we get a lot of residue cases where they catch them with just a little bit of drugs, and those people don't go to prison. They get some jail time. Hopefully, we're putting them on probation, dealing with their substance abuse issues primarily. Although if it's their 8th or 10th conviction and they just don't want to be on probation, sometimes we can try and force it on them, but it's hard to do.
I mean, I will say this: that the trend is no longer increasing. So the curve was looking like that, and it's sort of leveled out.
Yeah. So I think it's going to help. It can help with that, but I think what the changes that we made. Yes, sir.
You referred to evidence-based practices. In Washington, evidence-based is kind of code for science. And this Saturday, the American Association for the Advancement of Science is having a big demonstration about the politicization of science and the notion that we should make decisions based upon our beliefs, not evidence. Could you talk a bit, both of you, about the politics of trying to implement evidence-based practices that sometimes run contrary to gut feelings?
The simple answer for me is no, I can't. I'm not allowed to as a judge. I have certain things I can talk about, and certain things I can't. And one of those I can't talk about.
I'm not talking about advocacy. I'm talking about description of how do you get past the politics of this.
Well, let me see if I can fill in a little bit. So I do a lot of education of judges, of probation officers, of lots of folks in Nebraska about this very issue. And one of the things I'll do is I'll walk into a room full of judges. Judge Colborn will tell you, and I'll say to them, I'll tell you what, your intuition goes about this far, and the research I'm telling you about goes about that far, and it's much better than your intuition. And I'll just lay that out and say that to judges, and judges are fairly receptive to that kind of argument.
How about legislators?
Well, that's another story entirely. That's another story entirely. And there are legislators that are friends of evidence-based practices and friends of science that have that kind of background and training and listen to those arguments and will adjust their bills accordingly. And there are those that feel that their own intuition is in fact better than anything that the research is ever going to present. And so there are some people that it's like a religion. My intuition's better. I have a belief and a value, and you can't convince me otherwise. And I have to tell you, that's a hard argument to make against those individuals. But there are a lot of other people that if you can present them with logical arguments, hopefully like the kind of things that we were presenting here today, you can make some movement in the positive direction of suggesting that this is going to have a better outcome. I find that when I can say that this is going to decrease the amount of money you're going to have to spend on this particular problem, that carries a lot of weight. It's nice in this work that the kinds of things that are going to decrease the amount of money that you spend are also going to be the kinds of things that are going to improve the quality of life of the individuals that are in prison or on probation, because the two coincide. And in those kinds of areas, that argument it makes some points. But I'm with you, and I won't be here for the march this Saturday, but I'd like to be. But I'm with you that the important message there is that, and I think I started out this before the early part of the presentation that I'm afraid you weren't here for, but I started out talking about what it means to have good quality data and what it means to have evidence-based decision making, and how you can take experiential knowledge and you can take contextual knowledge and combine that with the science and come up with good policy. And the idea is to try to move in that direction. It can be a challenge and it can be a difficulty, and I speak to legislatures, and I've had arguments with legislatures, and I've in fact published things that made legislators rather angry because they're pointing out where their errors in logic are in policies and thinking about those issues. But I think in the end, as scientists, which of course is my role in all this, we have an obligation to keep putting that science in front of people's eyes, to look at and keep repeating it, and eventually, that's one of the roles of SPSSI. And eventually we try to hope for having some impact on getting policymakers to take advantage of the science and make more logical, reasonable definitions. So that's my soapbox that he couldn't say. But, and I won't say he agrees or disagrees, but I'll be happy to say that I think that's really what we have to do and what we're trying to do in the state.
Great. Well, I think it's 1:15. Our speakers are going to stick around, so please come up, ask additional questions. We have business cards out front. We're going to have some more congressional seminars in the fall, so stay tuned. Thank you so much to Judge Colborn, Dr. Wiener, Dr. Stanton, Congressman McGovern's office, and please stay in touch with us and feel free to contact us. We have experts and scholars on every social issue topic you could imagine, and I'm always happy to help connect people to those experts as needed. So thank you.